true no matter what the issue is, whether it's gun, abortion, health care, campaign finance? Does that process hold true for everything?
Yes, you always no judges can't just wake up one day and say, I have an agenda, I like guns, I hate guns, I like abortion, I hate abortion, and walk in like a royal queen and impose, their will on the world. You have to wait for cases and controversies, which is the language of the Constitution, to wind their way through the process.
All right. Well, Senator Sass gave us a good civics lesson. I hope that's the basic lesson in law here. So if a state said, I don't think you should have over 6 bullets, and somebody believed that violated the Second Amendment, there would be a lawsuit and the same process would work, right?
The same process would work. In that case, there would be parties would have to sue the state who, arguing that law was unconstitutional. It would wind its way up. And if it got to the Supreme Court, and if the Supreme Court decided to take it, a whole decision-making process begins. You hear arguments from litigants on both sides. They write briefs. You talk to clerks as a judge. You talk to your colleagues. Then you write an opinion. Opinions circulate, and you get feedback from your colleagues. So it's an entire process. It's not something that a judge or justice would wake up and say, oh, we're hearing this case. I know what my vote's going to be.
Let's talk about the 2 Supreme Court cases regarding abortion. What are the 2 leading cases in America regarding abortion?
Well, I think most people think of Roe versus Wade, and Casey is the case after Roe that preserved Roe's central holding, but grounded it in a slightly different rationale.
So what is that rationale?
Rationale is that the state cannot impose an undue burden on a woman's right to terminate a pregnancy.
Okay, unlike Brown, there are states challenging on the abortion front. There are states that are going to a fetal heartbeat bill. I have a bill, Judge, that would disallow abortion on demand at the 20 weeks, the 5th month of the pregnancy. We're one of 7 nations in the entire world that allow abortion on demand at the 5th month. The construct of my bill is because a child is capable of feeling pain in the 5th month. Doctors tell us to save the child's life, you have to provide anesthesia if you operate because they can feel pain. The argument I'm making is if you have to provide anesthesia to save the child's life because they can feel pain, it must be a terrible death to be dismembered by an abortion. That's a theory to protect the unborn at the 5th month. If that litigation comes before you, will you listen to both sides?
Of course, I'll do that in every case.
So I think 14 states have already passed a version of what I've just described. So there really is a debate in America still, unlike Brown versus Board of Education, about the rights of the unborn. That's just one example. So if there's a challenge coming from a state, if a state passes a law and it goes into court where people say this violates Casey, how do you decide that?
Well, it would begin in a district court, in a trial court. The trial court would make a record. The parties would litigate and fully develop that record in the trial court. Then it would go up to a court of appeals that would review that record looking for error. And then, again, it would be the same process. Someone would have to seek certiorari at the Supreme Court. The Supreme Court would have to grant it. And then at that point, it would be the full judicial process. It would be briefs, oral argument, conversations with law clerks in chambers, consultation with colleagues, writing an opinion, really digging down into it. It's not just a vote. You all do that. You all have a policy and you cast a vote. The judicial process is different.